of the Alfred Olango Foundation. They said they were not going to let this go in the dust. They were going to start something that continues to fight police reform. So let's give them a big hand for this commitment. The Alfred Olango Foundation is just the beginning of dealing with police reform and culturally bringing us together, from African to African American to Latino. We've got to fight police reform. And the Alfred Olango Foundation is the beginning of us in different cultures working together.
At the end of Reconstruction, police in southern states enforced a series of vagrancy laws and black codes that were passed by state legislatures after the Civil War to keep the disenfranchised, including the newly freed slaves, from advancing economically or having true freedom. For instance, after the Civil War, the South suffered a shortage of labor. 8 southern states established convict leasing, the hiring of prisoners for laborious jobs. People suspected of being jobless were arrested and leased to plantations or businesses for work. African Americans weren't allowed to own property or businesses of their own, and they were kept from voting or taking office. In 1892, a New Orleans man named Homer Plessy decided to challenge these laws. Plessy boarded a first-class white train and was asked to move to the blacks-only train. He refused and was arrested. He sued, and the suit made it to the Supreme Court, resulting in the Plessy versus Ferguson decision. Not only did Plessy lose the case, but the case legitimized the establishment of separate but equal codes, beginning the era of the Jim Crow laws. Until the dawn of the Civil Rights Movement, state and local officials established laws separating blacks and whites from schools, cafes, universities, churches, restrooms, and even drinking fountains. Discrimination against African Americans prevented adequate funding for schools and stopped them from being hired at high-paying jobs or buying homes in prominent neighborhoods. The murder and lynching of African Americans continued without those responsible being arrested or charged. In many cases, law enforcement was complicit in the murders. By 1953, racial prejudices ran rampant throughout the country, including the South. Once again, the laws were challenged. The parents of a little girl named Linda Brown sued the Board of Education of Topeka, Kansas, in order to place her in a school that was closer to home, but was for whites. The Brown versus Board of Education decision of 1954 overturned the decision left by Plessy versus Ferguson. The Supreme Court had decided that keeping children separate simply due to skin color made them feel inferior, affected their development, and deprived them of equal protection laws. This enraged the South, and it would take years to integrate schools. Many schools chose to shut down or become private rather than integrate. In some extreme cases, the state capitals rose a Confederate battle flag over their buildings, or put up statues of Confederate heroes to send a message to African Americans looking to settle down. In Alabama, in 1955, a young woman named Rosa Parks walked into a bus, paid her fee, and sat down near the front. When she was asked to move to the back of the bus to allow a white man to sit in front, she refused. Parks was arrested, which would kick off the Montgomery bus boycott, led by a young reverend named Martin Luther King Jr. After a little over a year of successful boycotting that included violence and a bombing of King's home, the bus company gave in and changed their codes, bringing both King and Parks into prominence and kicking off the 1960s civil rights movement. By the dawn of the 1960s, resistance to the civil rights movement turned the decade into a time of turmoil as legislation after legislation passed both for and against freedoms for the less fortunate, and race relations grew to a boil. First, there was the Civil Rights Act of 1957 and of 1960, which further expanded rights for African Americans. Sit-ins began across the South, and when they arrested and jailed Martin Luther King for participating in a sit-in in Atlanta, presidential candidate John F. Kennedy helped to secure his release. When Kennedy was inaugurated as president, He promised to fight for civil rights abroad as well as at home. Then there were the Freedom Riders, driving from Washington, D.C. to New Orleans on a bus to test voting ordinances. When they firebombed the first bus and beat the passengers, more people took their place in a new bus. When those people were arrested as they arrived in Jacksonville, Mississippi, even more people took their place. There was the 24th Amendment, which ended poll taxes that prevented the disadvantaged, including African Americans, from voting. There was also the Supreme Court case of Mapp v. Ohio in 1961, which created the exclusionary rule, a product of the 4th and 14th Amendments. It meant that if police used a warrant to search your home, and whatever they found was not part of that warrant, it would be excluded from prosecution. Police could not just burst into a home and use whatever they found inside to charge and convict people. It now needed to be included in a warrant. One of the larger events was the Civil Rights Act of 1964. In June of 1963, the bill that would outlaw segregation and Jim Crow-type laws and required all voter registration applications to be processed equally was introduced to the House. 2 months later, the March on Washington for Jobs and Freedom took place, where Martin Luther King gave his I Have a Dream speech. President Kennedy supported King and the Civil Rights Bill. Unfortunately, Kennedy would be assassinated by November. Kennedy's death put additional pressure on the House Rules Committee to pass the bill. The next president, Lyndon B. Johnson, gave a joint session speech advocating for full passage of the bill, and public support for it grew. The House would pass the bill, but when it reached the Senate, it met more resistance. There was a bloc of both Republicans and Southern Democrats who filibustered the bill for 54 days before the bill finally passed the Senate. President Johnson signed the bill into law. Yet, when King asked Johnson to support a Voting Rights Act the following year, Johnson was hesitant to get behind the idea. A Democrat, Johnson had feared that his wheeling and dealing in getting the 1964 Civil Rights Act passed had already ruffled many in the South, and he feared another legislative win for civil rights would flip the South into Republican territory. Demonstrations like the marches from Selma to Montgomery helped keep the issue of civil rights and voting rights alive, despite Johnson's lack of help, and the following year, Johnson decided to support and signed the Voting Rights Act of 1965. After a man named Ernesto Miranda was interrogated by police for hours without a lawyer, he made a confession and was sentenced to prison. He appealed the conviction, arguing that he did not know that he had a right to remain silent. The case made it all the way to the Supreme Court. He won the appeal, and since then, officers have been required to read Miranda warnings to those they arrest, informing them of their rights. Richard and Mildred Loving were an interracial couple living in Virginia who were arrested in their home in 1958. They were found guilty of violating interracial marriage laws and banished from the state. They found lawyers to appeal their convictions, and in 1967, the Supreme Court ruled that laws prohibiting people of different races from marrying was unconstitutional. From here on, men and women of different races were able to come together in matrimony without legal consequences. The last civil rights bill was passed in 1968. In 1967, another Supreme Court decision, Garrity v. New Jersey, established the Garrity warning. The Garrity warning is similar to a Miranda warning, except it was designed to let officers who are under investigation know their rights. With suspicion that officers were being bribed in New York City, another officer named Gardiner was subpoenaed to testify to a grand jury. His superiors tried to force him to sign a Fifth Amendment waiver, but he refused and was fired for not testifying. Gardner sued, and in Gardner v. Broderick of 1968, the Supreme Court decided that the previous Garrity decision also protected the officer's right to free speech, and so his firing was found unconstitutional. There were the assassinations of civil rights leaders Malcolm X in 1965 and Martin Luther King in 1968, leaving the movement devastated as angry rioters took to the streets of America. King had slowly began to realize that the issue of race lay under a larger umbrella of class, and so came to Memphis, Tennessee to lead a sanitation workers' strike. He was shot at the balcony of his hotel. By 1971, Richard Nixon was the new president. The two groups that Nixon considered enemies were African Americans and hippies, who were largely opposed to the ongoing Vietnam War. Their solution was to associate them with drug use, specifically marijuana to hippies and heroin to African Americans. Next, they would call for legislation that served heavy penalties for drug use and possession, essentially turning these groups into criminals. With jails being filled with the disadvantaged who were being vilified in the media, their movements would essentially be discredited. This was the beginning of Nixon's war on drugs. The war on drugs greatly increased the amount of people imprisoned, and those people were disproportionately black. With more prisoners came more guards and facilities and the need for more money to maintain them. The old convict leasings and vagrancy laws gave way to a prison system that became an economic boom for business at the expense of the disenfranchised. What emerged was a prison industrial complex that kept many of the less fortunate from economic advancement. With the need to keep prisons full came the urge to better protect the police officers that fed the system. In 1974, the legislature in Virginia passed the country's first Law Enforcement Officers' Bill of Rights. 13 more states, including California, would pass their own version of the bill. The LEO Bill of Rights is a set of extra protections given to law enforcement officers who are under investigation, which the civilian public does not have. For instance, in Maryland, police officers accused of a crime have 10 days to make a statement, while civilians do not. Because officers can only be questioned by other officers according to this code, it makes something like a civilian review board nearly impossible to accomplish in these states. In Rhode Island, officers can be convicted of crimes without being fired. In most states, departments don't even have to acknowledge that their officers are under investigation. This kept potentially dangerous officers on the force, which in time would tarnish a department's reputation with their community. As people of higher classes began using powdered cocaine, producers found a way to make a cheaper and smokable version of it called crack. As crack made its way into poor communities, laws were passed that treated sentencing for possession of crack cocaine differently than from powdered cocaine. Those possessing crack cocaine would get much harsher sentences than those possessing powdered cocaine, causing further racial disparity. In 1989, a man named Graham walked into a store to buy orange juice, but changed his mind when he walked in and saw a large line. He walked out of the store, but was pulled over by an officer named Connor, who saw Graham walk in and out and became suspicious. He detained the man, putting him in handcuffs until it was determined that no wrongdoing had occurred. Graham sued, and in the Graham versus Connor decision, the Supreme Court decided that when an officer uses force, the perspective of the officer, not hindsight, is what determined the reasonableness of that force. This meant that if an officer was accused of using excessive force, but truly believed that it was necessary to apply that force at the time, they could be acquitted. There is no practical reason to exclude hindsight from any case other than to protect an officer who stepped over the line. This can also be expanded to mean that an officer does not have to factor in disabilities such as age, hearing loss, mental illness, or pregnancy when applying force, as long as the officer can prove that he was in some sort of fear at that moment. Of course, how force is applied could be just as disproportionate. In March of 2012, a short documentary was released addressing an African war criminal named Joseph Kony. The documentary became popular, but its creator, Jason Russell, suffered a mental breakdown in public. He was unarmed and mental illness is not a crime, so he was safely detained by police for psychiatric evaluation without incident and was hospitalized for weeks. because of the help authorities provided him, Russell was able to recover from his breakdown. Then, in 2013, a Florida neighborhood watch named George Zimmerman was acquitted of shooting to death an unarmed African American named Trayvon Martin while he was on his way home from buying candy. The following year, in Ferguson, Missouri, a police officer killed another unarmed African American named Michael Brown, and his body was left laying in the street for hours. This caused an outcry and unrest in the Ferguson community as police began to militarize themselves against local protesters. In response, activists began to organize nationwide and movements like Black Lives Matter emerged. As social media grew, so did the outcry as more unarmed African Americans such as Eric Gardner, Tamir Rice, Freddie Gray, and Philando Castile were killed on camera by police officers. The issue of police brutality and excessive use of force became a main topic in American discourse. Yet, because of legislation like the Law Enforcement Officers' Bill of Rights and Supreme Court opinions such as Graham versus Connor, none of the officers involved were ever convicted of a crime, and most of them kept their jobs. Finally, in September 27, 2016, in a parking lot in El Cajon, California, a police officer shot and killed an unarmed Alfred Olango as he was suffering a breakdown. The movement had finally hit home.
Like no type of compassion, y'all just killed her brother.
Racism exists! Racism exists!
Anyone of us did it.
He's 16!
They didn't inform her of anything. They had no type of compassion for this lady.
No justice! No peace! No justice! No peace!
Immediately dispersed. If you do not do so, you will be arrested.
Alfred wasn't hurting anybody. He wasn't doing anything to endanger or harm anyone. We've got to get them out, and we come to create a movement.
About 150 people marched along Sunset in Hollywood.
I hope Alfred Olango is remembered as someone that sadly lost his life in a situation that he wasn't supposed to, but in doing so was able to give something to a people.
He had no weapon. My son is a good, lovely young man. Pain. It is so much that you cannot swallow it. You try to swallow it, but the pain overweighs you.
We fight to win. We shall win. Arambe! Arambe! Arambe!
This problem is bigger than any one of us. So what can we do to change this habit of unarmed killings? We can organize and we can network. We can educate and we can take action. The Alfred Olango Foundation feels that the police are a vital component to a safe and thriving community, but is in need of certain reforms that will reestablish the trust between police and the communities they are duty bound to protect. By focusing on community outreach, legislation, and officer training, we can make the changes that will not only reestablish trust between police and the communities, but will also save many untold lives.